So, good morning, my dear respected ISA Pune senior members, Dr. Vivek Rani, my colleague, and my dear students. We are today going to discuss very fundamental things about uh, patents, basically, because I have seen that even though we have ideas, students have many ideas, but they are not coming forward for filing the patent and making the use of those ideas. So that is the main purpose behind this. Just it is a motivation for the students and get into the patents. So intellectual property right, which is also called as Bodhik Sampada, another name is Bodhik Malmatta, and the main content, it is divided into four parts. Patents, basically. Second one is trademarks. Third one is graphical indications and designs. Now, what is patent basically? A patent is an exclusive right which is granted for an invention which is a product or a process that provides in general a new way of doing something or offers a new technical solution to the problem. So this is the basic idea behind the patent. Patent basically it is an exclusive right. It gives exclusive right to the invention who has invented it, and that may be a product, that may be a process, that may be a new way to develop something, doing something. So this is what is patent. Second is to get the patent, technical information about the invention must be disclosed to the public in patent application. This is the important thing. We have to declare, we have to disclose the whole information in publicly. Next, what is the example of the patent? If you look at the example of the patent, the light bulb was an invention and it was patented. IC engine also it was patented. So these are the two examples just given for understanding purpose. What is trademark basically? A trademark is a sign capable of distinguishing the goods or services of one enterprise from other enterprises. So this is a trademark basically, which is a distinguishing feature or distinguishing thing from one enterprise to another enterprise, and trademarks are protected by intellectual property rights. Let us see the example of the trademarks. Distillery is a good example of the trademark, and 7 o'clock saving razors is also an example of the trademarks. Next is graphical indications. As far as geographical indications or graphical indications are concerned, the geographical indication is a sign which is used on products that have specific geographical origin, and it possesses qualities or a reputation that are due to that origin. This is very important. So this is called as geographical or graphical indication. To function as a GI, a sign must identify a product as originating in each place. So where it has originated, that place is very important for the geographical indication. The example of the geographical indication is Darjeeling tea, for example, Solapuri chadar. So these are some of the geographical indications which can be patented. Next is designs. As far as designs are concerned, in a legal sense, an industrial design constitutes the ornamental aspect of an article. So whatever design we are making, that design also can be patented. And an industrial design may consist of three-dimensional features which has shape of an article, or two-dimensional features such as patterns, lines, or colors. And simple examples of these design are original curve Coca-Cola bottle. That shape of the bottle is example of the design which was invented in 1915, or it was patented in 1915. And Statue of Liberty is another example of the design. So these are the four types of IPRs. Now, as far as intellectual property is concerned, the next extension of these, earlier it was limited to 4 groups. Now it has been extended to earlier one that we have discussed. Copyright is one, trademark is one, geographical indications, then patents, then plants, variety protections, designs, and nowadays, very recently, the semiconductor layouts also can be patented. When we talk about the copyright is a grant to the books, musics, paintings, sculptures, and films, computer programs, database, advertisements, maps, technical drawings, etc. The legal provisions for copyright were made in by the Copyright Act, which came into force in 1957, and it is administered by Copyright Office, Ministry of Commerce and Industry, Government of India. And the duration for the copyright is around 60 years. The longest duration copyright offers to the literary or these music, books, etc. This is a copyright that we have just seen. Next is trademark. Trademark, we have already discussed what is trademark, and it is administered by DPIIT, Ministry of Commerce and Industry, which is nothing but Department of Promotion of Industry and Internal Trade. Then geographical indications. Sorry, I just forgot to tell. Trademark is valid for 10 years. Duration for the trademark is for 10 years. Next is geographical indications. We have just discussed it. It is comes under control of DPIIT, and the duration for this is again of 10 years. Next is patents. Patent comes under the legal provisions of Patent Act 1970, and it is again administered by DPIIT, Ministry of Commerce and Industry, and the duration for patent is 20 years. Then plant variety protection. This is a new thing which is recently added in 2001, basically. The Protection of Plant Varieties and Farmers' Right Act 2001. And it is administered by Ministry of Agriculture. It is valid for 15 years for the field crops and 18 years for trees and vines. Next is design. Design is valid for 10 years and it can be extended by 5 years. Next to that is semiconductor layouts. As technology is growing, semiconductor systems, semiconductor designs are also growing. It came into force in 2000 and it is again controlled by Department of Electronics and IT, Ministry of Communication and IT. The validity for such kind of patent is 10 years. Now let us see in short the brief history of Indian patents. 1856 was the beginning of Indian patent system. The Act 6 of 1856 on protection of inventions based on British patent law came into existence. Certain exclusive privileges granted to the inventors of new manufacturers for the period of 14 years. Then it went on increasing. In 1952, some modifications were, 1859, some modifications were made. In 1872, again the Patents and Design Protection Act came into existence. 1883, the Protection of Inventions Act came into existence. 1888, consolidated as an Invention and Design Act. 1911 came as Indian Patents and Design Act. 1999, the patents on March 26, patents came into force from 1/1/95 basically. Then 2002, the Patents Act, again modifications in that act came into force. 2005, the Patents Act 2005 became effective from 1st January 2005. These are the upgradations which are continuously being made from Patent Office. There are some amendments, and those amendments will come force year by year. The latest amendments to these rules are made in 2024. Now, why to file the patents? Motives, basically. The first motive is to blocking the competitors from entering their technological domain. Suppose you are manufacturing something, you are doing something, you can block your competitors by filing a patent on your design or on your idea. Increasing the bargaining power, you can increase the bargaining power. Once you have a patent in your hand, then you can increase the bargaining power. Next, you can secure the freedom to operate. You can gain time for evaluation of the patent. You can enhance the reputation. Your reputation, your brand reputation will increase if you have a patent on your name. Then forum against infringement suits. Infringement is basically the breaking the patent. If somebody has taken the patent and if somebody tries to play with that or tries to manufacture the same, we can file the suits, infringement suits against such vendors or such people. And last one is the secure priority. So these are the motives basically why one should file the patent basically. Now patent term, this I already told you, 20 years from the date of filing. This is very important. The day on which you file the patent, from that day, when it gets granted, that is a different thing, but you can get the protection for 20 years from the date of filing. Now patent protection, the very important thing I would like to mention here is that Indian patent do not give the protection worldwide. This is a very important thing one has to understand. Once you file the patent, that too in Indian patent, you cannot claim that worldwide. Patent protection is a territorial right and therefore it is effective only within the territory of India. I hope I am audible to all.
Yes, sir.
Yes. So patent protection is a territorial right, regional right basically, and therefore it is effective only within the territory of India, being Indian patent. There is no concept as global patent. You cannot file a global patent or it does not exist even. But one thing is true, however, filing an application in India enables the applicant to file the corresponding application for the same invention in convention countries. This is very important to understand. If somebody wants to file the same patent in other countries, you can file one application under PCT, which is known as Patent Cooperation Treaty, wherein some of the countries are under that roof. And once you file that application under PCT, you can file your patent in other countries also, which are part of that PCT. And that too we have to file. That too we have to file before the expiry of 12 months from the filing date in India. This is very important for filing the patent. If you find that your patent is very exclusive, it is having a very good concept, you can file that patent in other countries also. And for that, you have to file the PCT for that. Then patent should be obtained in each country, that I already made clear, right? So you cannot get the patent in other countries by just filing a patent in India. This is an important thing one has to understand. Those who wish to undergo or file the patent, basically. Now, certain facts. What is the criteria? Many people ask that what is the criteria for patentability, and that criteria is very important whenever you are to file the patent. An invention basically is patentable if it meets the following criteria. First is, which is very, very important, right? And it should have the novelty. In the invention that you are going to file, invention that you are going to patent must have the novelty within. This is a very important primary condition for the patent. Second condition for patent is it should have inventive step or it must be non-obvious. This is another mandatory condition for grant of the patent. And third and most important, it should be capable of industrial applicability. Means whenever you are designing something, whenever you have an invention, that invention must have the industrial applicability. I hope you understand this. So these 3 points one has to check before filing the patent, or we have to arrange it in such a way. We have to find out the novelty in the patent. We have to find out the inventive step that we are taking, right? And you should also check that it must be non-obvious one, right? And third one is it should be capable of industrial applicability. These are the mandates as far as patents are concerned. It should not attract the provisions of Section 3 and Section 4 of the Patent Act 1970. In Section 3 and Section 4, there are some conditions. If you overrule those, then that patent validity will not be there. We will not go into the details of that. Generally, an invention which has been either published, right, can be, means basically there is a question always. Can any invention be patented after publication or display in public exhibition? Generally, an invention which has been either published or publicly displayed cannot be patented, as such publications or public display leads to lack of novelty, because novelty will not remain over there. And that is why if you have any idea, you are not supposed to publicly expose, publicly exhibit the same idea. That is the important thing. However, under certain circumstances, the Patent Act provides a grace period of 12 months for filing of patent application from the date of its publication in journal or its public display and exhibition organized by government or disclosure before any learned society or published by applicant. Suppose you publish that patent in the journal, you have 12 months period, you can file it, we can file the patent. It has to be published in the journal or it should be published in the government disclosure, basically. This is the condition for this, but as far as possible, we are not supposed to disclose your invention publicly. Is it clear? I hope I'm going in the right direction. Are you getting the answers, audience?
Yes, sir.
Yes, sir.
Okay. Now, who is eligible to apply? That is again a question in everybody's mind. A patent application can be filed either by a true or first inventor or his assignee, either alone or jointly with any other person. Means the person who has invented something, who has that invention, he can file the application, or his organization, true organization, right? So they can file the patent jointly, or you can also file the patent with other person who are involved in that invention. However, the legal representative of any deceased person can also make an application for the patent. So legal representative, you can file the patent through the legal representative in case of any deceased person. Then how to register for online filing of the patent? Many times in earlier case, even I have experienced that we have to go to the regional office for filing the patent. I had been to the Mumbai office for filing the patent when from our institute, first 30 patents were filed. I was fortunate enough to get that opportunity from my organization, and I have visited IIT Mumbai, Patent Office Mumbai for this case, and we registered the patents over there. But nowadays, as online system has become more and more powerful day by day, right? So now patent can be filed in the online way, but there are certain things which are to be matched. First one is to register for the filing of patent application. The user is required to obtain the class 2 or class 3 digital signature. This is an important condition. You can get that digital signature from any of the agencies who are providing the digital signatures. And once you get the digital signature, by putting it into your system, you can file the patent. Second thing is, after obtaining that digital signature, the user has to register on the portal by CGPDTM, which is Controller General of Patent, Design and Trademarks. The website is given over here. You can go to the website, create your ID and password. And once you create your ID and password, you can file your patent. The signatures are required to sign the documents. Basically, we are uploading Form 1, Form 2, whatever forms are there, those needs to be digitally signed before it is being uploaded. So for that purpose, we need a digital signature. Approximately the yearly expenses for the digital signature are around 1300 to 1400 basically. So if you go for 2 years, 3 years, then you will get some concessions, right? So you can obtain the digital signature. There are many agencies, as I have mentioned. Then an application for the patent can be filed either in Hindi or English. You can file the patent, Hindi being our language, right? And English is a common language which is followed world over. You can file the patent application in Hindi or in English. Then what are the types of applications? Many times there are different types of applications. One has to understand that. First one is a provisional application. Provisional patent application is an application which is to be filed as per Indian patent law, right? Which follows the first to file system. A provisional application is an application which can be filed if the invention is still under experimentation stage. This is important. If you have some idea, you are under experimentation, but you haven't yet come to the conclusion that these are the things that I am going to make out of this patent. Why those things are to be identified, we will come to that when we will reach the claims. Claims are very important, and in that it is required. So a provisional application must be filed if your work or the invention is still under experimentation stage. Filing the provisional specification provides the advantage to the inventor since it helps in establishing a priority date of invention. If somebody files the application of similar kind after your filing, then your right will be retained. This is very important. That's why whenever we have an idea, we have some concept in your mind, you can file the provisional application before you go for the finalization of it. Further, the inventor gets 12 months time. Once you file the application, you will get 12 months time within which we have to file the complete specification for the application, right? So about fees, we will come to that. But here I would like to mention, even if you file the provisional application, you and the whatever fees we are paying by that time of provisional application, you need not to pay a single penny for filing the complete specification. This is an important point to note over here. What is the fees? How much has to be paid? How it is to be paid? That we will come to know in the next discussion. Then ordinary application, an application for the patent filed in the patent office without claiming any priority, either in convention country or without any reference to any other earlier application under process in the office, is an ordinary application. Such type of application is known as ordinary application. Then convention application. Convention application is claiming the priority date, right, based on same or sustainability similar application filed in one or more convention countries. PCT, that I have already mentioned. The date to get convention status, an applicant should file the application in Indian Patent Office within 12 months from the first date of filing. This I have already made clear. PCT application we have to make if you want to file the application in other countries, convention countries. Then these are other application types. PCT, which is known as Patent Cooperation Treaty. Under that you can file the patent in 150 countries. This is very important, which are part of that PCT. Then national phase application, PCT, when an international application is made according to PCT designating India, an applicant can file the national phase application in India within 31 months from the international filing date of or priority date, whichever is earlier. Then patent of addition. Suppose you have done or filed one patent and you have the extension of that, you have some additional to add on to that patent, then patent of addition can be filed. When an invention is a slight modification of the earlier invention for which it has been already applied for or has obtained the patent, the applicant can go for the patent of addition. This is one important thing one inventor has to understand. Suppose you are doing some extension work to the earlier patent, you can file the patent of addition. What is the benefit of that? One of the benefits of filing the patent of addition is that there is no need to pay separate renewal fee for the patent of addition during the term of main patent, and it expires along with the main patent. This is important, right? So whenever you are doing that, we have to see that the patent application or patent of addition is filed, because after grant of patent also we have to apply for the, we have to renew the patent and we have to pay the renewal fees. So for additional patent or patent of addition, you need not to pay the separate renewal fees. This is the advantage of this one. Then divisional application is one more type. When an application claims more than one invention, the applicant on his own or to meet the official objection on ground of plurality or distinct invention may divide the application and file two more applications for each of the invention. Suppose you know that your patent is, has wide scope, you can file separate applications, and for that divisional applications will be useful. This type of application is divided out of the parent one and is known as divisional application. The priority date for all divisional applications will be same as that of the patent, the original patent application. So these are, see, one thing one must have understood, that whatever comes, whatever date is considered is your date of filing. So this is very important. Whenever any infringement is there, whenever you want to have a patent of addition, whenever you have a patent of divisional application, everywhere the priority date is very important. Then duration, every application for the patent is published after expiry of 18 months. This is a natural publication of the patent, right? So once you file the patent today, from today, after 18 months, naturally your patent will get published. And if you don't want to wait for this, however, you can give an application which is called as the early publication, right? Application in which secrecy direction is imposed. In such cases, we can file the form additional application, and that will be early publication. So this is again important for us. If you know that your patent is important, then you can file the early publication for the patent, and there is a separate fee will be charged from the patent office for that patent. The application which has been withdrawn 3 months prior to 18 months, right? So that is again a case. A very important thing is that the applicant can make a request for early publication by filing Form 9. This is very important. Form 9 can be prescribed, and we have to pay the fees for that. Now, in some cases, nowadays, there are some startups and you want to start some business, then patent office has given some additional facilities, additional provisions, and those provisions are called as expedited examination, right? The request for examination and provision for expedited examination. So you can speed up the examination process, and for that we can go for the expedited examination. The request for expedited examination can be filed within period of 48 months from the date of priority or date of filing. Again, that date of priority is important for us. For more details, kindly refer the rules, right? So we are supposed to refer those rules. Other than this, right? So expedited examination, we can file the expedited examination by filing a form 18 or 18A for the expedited examination. So these are the three forms that one has to file. You can file all these three forms simultaneously. Basically, form 2, which is a basic application, complete application, right? If it is provisional, then we have to wait till you confine the claims and all. Then you can go for the early publication of this. And next stage is filing the examination of the patent. The expedited examination is carried out on the following grounds. There are certain guidelines. First one is that India has been indicated as a competent international searching authority or elected as an international preliminary examining authority in the corresponding international application. There you can go for the expedited examination. Then the applicant is a startup. This is important. If you are a startup, you want to start the business, you can go for the expedited examination. Then that the applicant is a small entity. In that case also, we can go for expedited examination. The applicant is a natural person, or in case of joint applicants, all the applicants are natural persons. Then applicant or at least one of the applicant is female. In that case, you can go for the expedited examination. Next is that the applicant is a department of government. If it is a government department, they can also claim for the expedited examination. Then the applicant is an institute established by central, provisional, or state act, like engineering college or any establishment. They can also go for the expedited examination if they find that the patent that they are filing has tremendous potential into it. That the applicant is a government company as defined by clause 45 of section 2 of Companies Act. So this is important again. And that the applicant is an institution, as I have already told you, the applicant is an institution wholly or substantially financed by the government. Next, the applicant or application pertains to the sector which has been notified by central government on the basis of request from the head of the department of central government. So they can also go for the expedited examination. I hope you got the idea of the expedited examination. Means you can go for the early examination. Usually the time for the patent to get grant is approximately 5 years. But if you want to get, or if you are hopeful to get that grant before that period of 5 years or so, you can go for the expedited examination. The applicant is eligible under the arrangement, an arrangement for processing an application, patent application pursuant to an agreement between Indian Patent Office and Foreign Patent Office. In such circumstances, from A to J, we can go for expedited examination. Now, what is the life cycle of this? This is very important. I just mentioned that right from the filing of the patent. So here you can see that the priority filing means you are filing the first application. Then if you require, you can file the PCT for that. And the duration for that is approximately 12 months. So from the date of filing, you can file the PCT application within 12 months. This is an important period, 12 months within that. Or even if you file the provisional application, you have to file the complete application within 12 months from the date of filing of the priority application. I hope this is very simple. I am repeatedly telling you because many times we miss out the date and miss out the opportunity to grab or encash that patent. Then second stage of the patent is after filing and 12 months of period, right? Naturally, by natural ways, the patent will go for publication or it will be published after 18 months from the filing, date of filing. So after 18 months, you can file the patent. You can see your patent published automatically. But again, for that, as I mentioned earlier, you can go for the early publication for this by paying the additional fees. This provision is also there. So within a month, you can publicize your patent. This is important thing. Many people doesn't know this. There are all provisions which are available by paying some additional fees. Next to that is the examination. In examination, basically, again, the natural examination, it takes around up to grant, it takes around 5 years, as approximately 5 years I have mentioned over here. So if you want to avoid that period, you can go for the expedited examination. That is one clause or one facility that we are having. Or in natural ways, after 5 years, your examination will take place. And after that examination, you will get either grant to the patent, or there will be opposition for that. That is again there. Or you will get a first examination report for that. You have to again file that, right? Then opposition we can file, and once you get that, you can satisfy, or you can give satisfy the queries, then you may get a grant for the patent. Or after examination, there will be a refusal for the patent. Again, even if it is refused, you can go for the appeal. Now, let us come to the fees charged for the patent application in India, basically. So as far as filing, normal filing of the patent is concerned, 1600 rupees is the fees for filing the patent. Then if you want to go for the early publication, then we have to file the application in the form of Form 9, and for that we have to pay the fees of rupees 2,500 rupees, so that it will be published within a month, or maximum it will take 1.5 months for the publication, depending upon the rush at the patent office. Next is the request for examination. As I already told you, you can file the expedited examination, and if you don't want to go for expedited examination, once your patent is published, right, you can file the examination, request for examination. This is, we have to do on our own, and the charges for that are 4,000 rupees. So if you are filing those, you have to pay 4,000 rupees along with the form number 18. You have to fill up the form, and all the things can be done in the online way. That means if you want to file the complete patent, including your early publication and examination, it will cost around 8,100 rupees. And most of the students are not knowing that. Most of the people are not knowing that. They are going to the agents basically, but you can do it on your own. Once you know the process, I'm going to touch upon how to write that application, what are the important facts about that. We are going to cover it in the same session. Now, before you file the complete application or the provisional application, there is one form which is known as invention declaration form. Basically, by filing this form, or by filling that form, you are going to collect the relative information which is required for filing the patent application. The first is, you must have the title of the invention. Normally, the title of the invention, usually what people do is that they straight away give the name to that equipment, which will be easily searched. But the normal practice is the title of the invention must be tricky one. Direct disclosure or direct the idea should not be seen from the title of the patent. That we have to take care of. So title of the invention must be more creative, right? It should not directly disclose the idea basically. Then field of invention, there should be the field of invention. The field of invention must be mentioned in your application, and this in this you have to write, this invention relates to mechanical field, it relates to electrical field, it relates to biotechnology field, right? And why it relates to that we have to mention, because here you can read, this invention relates to the field that you have to mention. Thereafter, the advantages of the invention may be mentioned to bring out clearly the areas of application and the preferable use of the invention. This is very important. If you write it more precisely and correctly, then chances, because whenever the patent evaluation is going on, that time this information will be very, very important for the evaluator. The applicant may substantiate the industrial applicability of the invention in this part. Means we have to mention, go from broader area of invention to specific use or application of the invention. Means from broader perspective to the specific use of that, we have to go for. So this is very important part of that invention declaration form. So I hope this is clear. Any questions about this? field of invention. We'll take a pause for 5 minutes. Is there any question? Hello? I'm audible?
Yes, you're audible.
Yes. Okay, thank you. Next is background of the invention. Next point is also important. What should be there in the background of invention? The first para of background invention should give brief information about the area of the technology which you are using. Then mention closest development in the field, which or with examples like patents granted or published. So in background, that is where the patent search comes into picture basically. So I have given some sites at the end so that I'll give you the brief idea about how to search for the inventions, similar inventions, and that needs to be mentioned in this area or in this particular, under this particular title. So I just read it again. First para gives the brief information about the area of the technology, then mention closest development in the field with examples like patents granted or published or any relevant document which is available for the same. Explain disadvantages of existing known technology or method. This is a very important step one has to take. Even if you find that some invention, similar invention is there, then what we can do is how your invention is different than this. Or if you find some disadvantage of the previous invention, which looks similar to yours one, that needs to be highlighted in the background of the invention. Generally, this background of invention is very, leniently rated. But I suggest that it should be we should carry out some study and then you go for this background invention. Next para, we have to mention what is your invention and how it solves the existing problem and how it is different from existing one or closed prior art. So this is important again. So mention what your invention is and how it solves the existing problem. So if your invention is to solve the problem, then how it solves that needs to be mentioned in the background of the invention and how it is different from existing one. Even if you find the similar, many times what happens, somebody tells us that yes, this is existing, but many people are not open enough. They are not going to tell you that there is some distinct thing in your invention, and that distinct thing we need to identify as an inventor. This is a very important responsibility as an inventor. Then object of invention. Many times I have seen that, generally people pronounce it like a object or objectives of invention. Though it is objective, but it has to be mentioned that object of invention. You cannot change it like objectives of invention. So object of invention must be mentioned as it is. And what are those objects? How those are to be given? The first is, please narrow down your object of invention. What is the purpose? Basically, you have to mention, right? And how it is to be mentioned? The principal object of this invention is. Your first line will be the principal object of the invention is so and so, right? So this is your first object. I'm again saying that don't write the principal objective of. Keep the sentence same, dicto, as per whatever is mentioned. Then second is another object of the invention is. Again, I'm saying that what is the another object, right? What is the another object of the invention? That we have to mention. Then further object of the invention is like that. Then yet another object of the invention. Likewise, you can go on adding, and approximately 5 to 6 objects must be mentioned in the object of invention. And this is a very important thing you are supposed to, because see, like as you are the inventor, you must know what is the purpose, what are the objectives which this device is going to serve for. And likewise, we have to mention the objects of invention. Then next comes is summary of invention. In summary of invention, we are supposed to explain the distinctive features of the invention for which the protection is looked for. Right? Even if there is existing thing and you added something to that, we cannot claim that existing thing, but added thing we can claim. And that is why what is the distinctive feature of your invention, and for which we are asking for the protection, that must come in the summary of the invention. Then brief description of drawings. Minimum 2 to 3 drawings must be given for each patent, because when it gets published, the abstract of the invention and the drawing, basic drawing of the invention will be published in the journal normally. So brief description of the drawings has to be given. For example, the title of the figure, figure 1, figure 2, title of the figure, likewise. So what is that? So in brief description, we are not going to write the detailed description of the figure. Here you have to mention only what that figure is about. And if you want to mention something about that figure in 1 to 2 lines, you can write. But don't give the total description of that figure over here. Right? Then second thing is, another figure also you have to mention, and likewise, suppose you have 2 to 3 figures, or even if you have more figures, you have to just mention it in the brief description of the figure. Label the parts. Labeling is also an art. Normally we label the parts like giving some name to that, but usually it is to be practiced that those labels are to be given in the form of number, and those numbers will be explained or will be mentioned whenever we are giving the broader description of the drawing, which is the next step of this. So label the parts of your drawings in numbers, and then use that number in bracket while mentioning that particular part of the invention while describing it. So many people are not doing this. I have seen that, especially the students. Generally, they make the mistakes. They just draw the block schematic and all. They give the names to that. But it is expected that the drawing should accompany the numbers, basically. Next is detailed description. As I already mentioned, you have to write down the detailed description of each figure and the correlation of that figure in total functioning of your invention. So that has to be described over here. You can write maximum possible things for this, right? So here you can describe the things, every small thing you can describe over here, and every part which is mentioned in the figures should come in this description, basically. If it is a process of making any final product, mention the composition first, then the source, what is the ratio or proportion that needs to be mentioned in the detailed description. Generally in pharmaceutical industries, or this procedure is required. If you are making a product in Ayurvedic product also, this process is very important. Then next we have to explain the process of making the product in a stepwise manner. How that product was made, that has to be mentioned. For showing the steps, you can use the flowchart as well. This is also a good idea to give the flowchart for your process, so that every step of the process can be mentioned in the flowchart. Give some examples of making your product in different possible proportions. That has to be given again. Do not forget to explain the commercial potential of the invention. This is to be written in the detailed description. What is the commercial value of this patent? How it will be helpful? What are the commercial possibilities of that? That has to be given. Last but not the least, most important thing, claims. What is basically a claim? Claim defines the boundaries of exactly what is protected by a patent. So claims are the boundaries of your invention, right? So whenever your patent is granted, it will be granted on the basis of the claims, right? So that is why it defines the boundaries. Basically, one has to understand that the most important part of the patent application is claims. Set forth what it does. Basically, it set forth the scope of protection afforded to the patent owner by the patent. What are the things, what are the rights which will be given if the patent gets granted? Claims drafting is a combination of science and art. As I mentioned earlier, drawing, making the sketch is also an art. Similarly, drafting the claim is also an art as well as it is a science also. So whenever we are drafting the claims, we have to understand that. You need to understand and identify the invention from technical standpoint, science point of view, and you need to craft the right combination of words and phrases in the claims to capture the key aspects of invention as broadly as possible while avoiding the prior art. So whatever comes in the prior art, that need not to be mentioned over here. How your patent, how your device, how your invention is more superior than the prior art, that has to be mentioned. So you can claim the things which are of your own. Then what are the types of the claims? In claims, you can say that there are two types of the claims, dependent and independent claim. So I'll just give you the example. Dependent claim means one main claim and subclaims, which are dependent on the main claims. And you can also give the separate claims also. Those claims are called as the independent claims. Then protection afforded by the claims. The exclusive right to control who practices, makes, uses, sells, offers to sell, or imports the invention as defined by the claims. So whenever you are getting the grant of the patent, everything which happens is only because of the claim. So writing the claim is a very crucial part of writing or drafting the patent. So as a inventor, we should know what is the speciality of our device, what we are going to claim about that particular device. Patent owners granted rights to receive damages from infringement and seek an injunction against the further infringement. If based on these claims, if somebody indulges into your area, you can file or you can go for the infringement, and that infringement is the opposite party will be called. You will be given a chance to explain, and once it is proved that your invention is your first claim, then you can get the money for that breaking of the law. It is possible to ruin a good invention if claims are drafted poorly. This is very important sentence. If the claims are not drafted properly or they are poorly drafted, then it is going to ruin the good invention. So while giving or while claiming, while filing the patent, one has to understand this fact. Now, when as an inventor is ready to file the patent application to protect the invention, the inventor must know what has been invented. That is very important. Second is, does the inventor know what he wants to protect? As an inventor, you should know what protection I am claiming. This is important. Just by inventing something is not sufficient. So for that, we have to understand what claims or what he wants to protect as an inventor. How can you claim this invention in the patent application? So everywhere you will find that the claims are a very important and crucial part of the patent application. The claims define the scope of protection provided by the patent. Claims represent the written approximation of the abstract invention concept created by the inventor. Everything comes to the claim. Now let us see one example of the claim. Whatever we discussed was fine. We have to be very smart. We have to be very cautious whenever we are writing the claims. Let us take a very simple example. What is this? This is one stool. Now how it is written, how the claim is written, a sitting device. That's why I told you, they are not calling it as a stool. It can be anything whereon we can sit on, right? So a sitting device comprising first a seat, a place to sit. First one, at least one leg coupled to the seat to support the seat as elevated position. So this seat should be supported by leg. At least one leg should be supported. Why it is mentioned like that? They are not mentioned 4 legs, because there can be a single stand or single leg for that such kind of sitting device. So that nobody should claim that again. That as you have mentioned here, that 4 legs are there. I am having a device which will be having only single leg. So instead of that, we have to have a very broader scope. That's why they have mentioned in claim at least 1 leg coupled. So anything could be there, right? But that has to be clearly mentioned. Now, once the claims and all these things are over, then what is the process? What happens to the patent side, basically, or patent office side, which is known as patent prosecution in India, basically. So first thing that we are doing, we are filing a patent, right? If required, we are going for the early publication of the patent. We can request the patent office for the early publication. So your patent will get published earlier, or your patent will get published after 18 months period, right? Then next is, as I have already mentioned, that there is a request for examination. Form 18 has to be filed, and by filing that examination form, you can motivate the patent attorney to review your application at the earlier stage, or otherwise it will take around 5 years for the examination, first examination report. Then once these things are over, either you get a pre-grant opposition or patent grant, right? Or if nothing happens like this, then you will get a first examination report. And from the after examination, and in first examination report, wherever that evaluator is having some doubts, those will be mentioned in the first examination report. I was fortunate enough to answer these few of the first examination reports at our institute. So the due to time constraint, it is very difficult to show the content of that form. But mostly they are objecting these 3 points, which are very essential and crucial for filing the patent, which is the novelty, right? Innovation that we are expecting, novelty and industrial applicability. So they will say that there is no industrial applicability. They will say that there is no novelty in the first examination report. And in that you have to justify that our device, our invention is having all these 3 things together. Then you will get the grant for the patent, right? Then grant publication will be there, and post-grant opposition. If somebody objects that, then there will be post-grant opposition. So this is the overall process, overall journey of the patent, wherever the patent prosecution is going on. Now, there is one organization which is known as World Intellectual Property Organization. Many of us have heard that WIPO Academy. WIPO Academy, why I thought of mentioning it? Because for the beginners, WIPO Academy provides some courses, short courses, which are free. You can apply for those courses and you can get into those patent ideas. You can explore the field of patents by undergoing such short courses. And they are open to all students. Some courses are paid, some are free courses. So whichever free courses are there, and if one is interested in filing or making a career in patent, because see, after graduation, most of the engineering graduations, we can also have a great career as a patent attorney. And for that, there is one examination you have to appear for, and once you clear the examination, then you can become a patent attorney. For such examinations, you need to study the patent to the deeper level. The World Intellectual Property Organization, WIPO, serves world inventors and creators, ensuring that their ideas travel safely to the market and improve the lives everywhere. The basic purpose of patent is to improve upon the lives of the people. And we know that most of the patents are of that kind. Then next is intellectual property is a powerful tool for growth and sustainable development. This is very important statement, that intellectual property is a very powerful tool. Most of the time we don't know our branding, we don't know our value. And if you don't know the value, and if you don't try for the patent, you may lose many things, right? IP empowers people. It's an enabler which with the means to create jobs, grow enterprises, develop economies, and add social vibrancy. We help our member states to use IP to grow and develop. Now these are the patent search engines. For prior art, we need patent search engines. A very common search engine is Google Patents. There is separate website for this. You can go for the Google Patents. You can put that title, you can put that idea and search whether it is patented or not. Then USPTO is the United States Patent and Trademark Office. On this office also, there are some free databases in which you can search for patents. Then patent scope is again a wide spectrum of these patents which is available from WIPO basically. WIPO patent scope is a global patent database and search system developed and maintained by World Intellectual Property Organization. Then eSpaceNet, this is again a patent search engine and it gives free access to over 150 million patent documents. Many people don't know where to search. They only know the patent, Google Patents, but eSpaceNet is again having the free access. More than 150 million patent documents are available over there and we can get into the patent area. So this is all for today. For further information, you can contact me on this information, right? And with this information, the session is now open for discussion. Yes, any questions?
Any questions? Thank you, Arun sir. It was very informative session. It covered all aspects of the patent requirement, protection, registration, and the process. It was a very wonderful session. I hope there are takeaways to the members. Any questions, please? The forum is open to discussion.
Sir, this is Sagar. Hi.
Yes, Mr. Sagar.
Yeah. Can you little bit explore on more on the career opportunity as a patent attorney? I think that's more interesting for the new generation.